Hello and welcome back to the Gorton Law Immigration Channel. I'm Jamie Gorton. I'm the lead attorney at Gorton Law. We're located in Malden, Massachusetts, and we help businesses hire and retain world-class talent. We help families unite legally under the laws of the United States, and we represent the rights of aliens and residents who are in deportation. Today, I'd like to bring you a video about the form I-864, which is probably the most complex and the most confusing part of your average green card application. This video will be the second video in our series of common mistakes that people make in immigration applications, and we hope it's useful to you. You don't have to take my word for it. This is based off of an excellent article that Professor Charles Wheeler, who does work over at Clinic, their former managing director, an excellent write-up, gives a lot of information, and I'm happy to summarize it here and also give my own experience as a practitioner about how people can better deal with this very complicated part of the green card application process. Before we begin, though, here at this YouTube channel, we have our weekly sponsor, and our sponsor this week is Forgetting Your Microphone at the Office. We're at the home office. We're kicking back. My microphone is not. Before the year 2020, I don't think lawyers really needed to worry about where their computer microphone was located. What a world. Anyway, the 5 most common mistakes on the Affidavit of Support. What is the Affidavit of Support and why are people making mistakes on it? So the Affidavit of Support is the form I-864, which USCIS will use and also the National Visa Center will use to determine if the sponsor has enough income to support the intending immigrant at or above a specific level based on how many people are going to be in the household. And the number one mistake on my list is not calculating the household size correctly, because people trip up on this all the time, partially because the form is trying to help you count in a certain way, and also because terms can be unclear. But as a general rule, remember that you cannot double count anyone. And if you remember that tip, I think everything gets much easier. So you cannot double count anyone on the form, and that's important because the intending immigrant always gets listed on its own box. So who is in the household? Well, the sponsor is always in the household. The sponsor's spouse is always in the household, even if they're separated. The sponsor's unmarried children under 21 are also always in the household, even if they're not residing, and even if they're not counted as a dependent on the tax return. Anyone who is counted as a dependent on the tax return is also in the household. And the immigrants who are going to accompany the main immigrant within 6 months. So imagine that, grandpa has filed for his daughter, and now daughter has the grandkids. Well, if the grandkids are coming with the daughter within 6 months, they are accompanying them all together, and they all get counted into the same household at the same time. Professor Wheeler makes the excellent point that because of that 6-month rule, you can stagger the immigrants out over time. If you're in the United States, this is not likely something that you're worried about. If you're applying through a U.S. consulate, this might be important if you have a limit on the income for the household size, and staggering the derivative applicants could be very useful to make sure that everyone gets to qualify over time. The second most important thing to make sure of is that once the household size is determined, the income has to be correctly reported. And so the second mistake is not knowing the numbers, because there's 2 different numbers that have to be reported. One is current individual annual income of the sponsor versus total income as reported on the taxes. So the current individual annual income is the current income expected as of today for the sponsor on the form. And if the sponsor worked for the first 5 months as a as a waitress and making $20,000, but now that school is over, they're back to work full time and they are going to be working as a digital media assistant for $60,000. Well, you would use the $60,000 number, even though they didn't get that job until partway through the year, and they won't be making that full $60,000 amount in that fiscal calendar year for their taxes. So it is, how much money are you going to be making on an annual basis today in its current? Hopefully, this is approximately the same annual income that was reported on the last year's tax return. Because if you're going to be using things like wage statements, payroll slips, employment verification letters from the company trying to show that there is current annual income, yes, this is what the rules say should happen, but you might expect a request for evidence if you're doing it like that. Just forewarned is forearmed. Meanwhile, the total annual income is the amount that is reported off of the tax records. So we prefer that you get an IRS tax transcript, but if you have your Form 1040, that's okay too. You just need to make sure that that household's annual income is being reported on the I-864, even if it is joint income. So for example, joint sponsor is a married individual. The joint sponsor qualifies on the basis of their personal own income, but the spouse is also working and the spouse also has their own income. So on their taxes, they've reported $120,000 when each of them is only making $60,000. So you report the total amount, even if it's joint income, and the immigration will check. Immigration will look at the sponsor's own proof of income in terms of their W-2s and their 1099s, and that will clear up like whether or not the joint sponsor's income personally is sufficient. Whew. Those two were pretty hard. I think those two cover a large amount of the confusion out there for immigration consumers about the affidavit of support. But the next thing that you need to be aware of is the next one. That one was kind of a double header. That was, numbers 2 and 3 together. Number 4 is you need to know when to stop. So the affidavit of support is very inviting. It looks like it's asking you to give a lot of information about money in the bank, stocks, bonds, real estate, other assets. And if your annual income qualifies, you should just stop. Just put the pen down. The information that they're asking for is very invasive. And, I grew up in New Hampshire, so we don't like to give a lot more information to the government than we need to. So, in my opinion, I don't think that USCIS needs to know what the sponsor has in the bank account because the current annual income is sufficient. Beyond that streak in my own personality, it's also not very effective. The assets section on the I-864 is designed to help people overcome shortfalls of income where they had to demonstrate 48,000, but they only have 46,000, but they also have money in the bank. Well, the first problem is that it is not a dollar-to-dollar equivalency. In other words, you need $5 in the bank to make up for $1 worth of income. So the person who says, oh, well, I'm only short $2,000, no, they're actually short $10,000 in cash if they want to prove assets. If we're into the world, in my practice, just in my office, if we're in the world where we're trying to prove something with assets, we typically put the pen down and we say, we think there should probably be a joint sponsor. So what is the fifth most common mistake? And this kind of cures it all. This is good for what ails you, as we say. The fifth most common mistake is not knowing when to tap in the joint sponsor, because the joint sponsor will charge in, make the primary petitioner's income basically irrelevant, and takes over the case from there. So the person who's the joint sponsor can be anyone who is a U.S. citizen or resident as long as they're living in the United States, and they are able to qualify based on their household size. So now you do an I-864 for the joint sponsor, you count their household size plus the intending immigrant, you look at their taxes, you look at their W-2s, their 1099s, maybe their spouse does or does not need to also sign paperwork. That's different. And what happens in this situation is that if the joint sponsor qualifies, then it doesn't matter if the petitioner is short by a little bit of money. It doesn't matter if the petitioner is completely unemployed and has income of zero, because the joint sponsor is going to be stepping into the shoes of that petitioner. So the joint sponsor should definitely know what this is about and definitely understand that it is a promise that they are making to the government that could be a long-term promise. For more details, you should read the actual language of the agreement on the I-864 itself. But in the real world, what does enforcement look like for joint sponsors? Well, historically, enforcement actions don't involve joint sponsors if there's an enforcement action that arises from a dissolution of a marriage. And enforcement actions under I-864s are probably very rare anyway, because the intending immigrant will ultimately be able to work for 10 years and get into the Social Security program, or become a citizen, or die, right, is the other way that this agreement ends. And it's typically some action of that benefit, the beneficiary, that ultimately terminates the affidavit of support. However, in my office, we're always happy to talk to potential joint sponsors. We say very clearly, just so you know, this is a conflict of interest. I work for the beneficiary. I don't work for you, but here's what I know about the affidavit of support. Here's what you need to be aware of that you are doing. Here's when the promise ends, and here's what your obligations are. But again, if the intending immigrant falls below the poverty line, which means that they're not working on their own and they're not able to support themselves. So if they're not able to support themselves, and if the petitioner is not able to support them, and if therefore government assistance gets involved, then there is a potential cause of action or potential right of enforcement. So the affidavit of support is something that, in our experience, people like it when they are asked for help. People usually have nice, warm feelings about being able to help out someone else. And a little bit of education on what the I-864 is and how it works is usually welcome, and also very helpful in having a joint sponsor join in on the case. So the average immigration consumer who is looking at this and trying to cross-check their taxes and remember where they put their W-2s and understanding the difference between annual income versus total income as reported, having a joint sponsor is really not on their minds. But for a good number of people, having a joint sponsor ready and raring to go is going to be a critical component to getting the green card application filed, processed, and approved correctly. So as always, thanks for tuning in. Our contact information is going to be linked with this video. We're based out of Malden, Massachusetts. This is our world headquarters, but we serve clients from around the world. We'd be always happy to discuss your I-864 issues or assist you with a green card application for yourself or your family members. It's been great sharing this information with you, and we hope to be able to provide more in our Common Mistakes series coming soon.